Hello, everyone. Thank you for joining me for the compliance webinars for high value and low cost. This is Margie Falk, the HR Compliance Officer for HR Compliance Solutions. Now, we have a value-packed training here for you today. How would you like to reduce fines, penalties, and criminal sanctions by 80% by adding compliance risk management strategies that work? This is an automated webinar. We also have free customized compliance tools for all registrants. Now, many of you have been to presentations in the past, but if you haven't, this is a legal disclaimer indicating that I'm not an attorney, and I'm okay with that. Okay? In fact, it indicates that any information that I provide is not legal advice. In fact, more of the information that you will receive today is based on my HR compliance experience for about 14 years and is for information and training purposes. Now, every webinar that I provide, I offer free customized tools, checklists, policies, toolkits, okay? All documents that are customized and have been proven to reduce risk. Okay, and that's my commitment and my extra value for all of you. Today, we're going to have a few bonuses, and one of them is a free Department of Labor article on off-the-clock audits and how to mitigate compliance. You will need to know, especially now with the new overtime changes, that the Department of Labor is really taking a really aggressive approach on employers that don't pay overtime. So make sure you download this presentation and this article at the end of the presentation. Now, if you've been in my webinars in the past, you can see some different components that I add. And because I only really deal with HR and compliance in the workplace, I usually have a court case, a legislation that's coming, regulations and employment laws that are trending and that are changing. And there are so many of those. So I'm glad you're here today. I also have regulatory agency seals. Now, some of these you may be very familiar with, or you may learn about one or two more. Now, also you need to be aware that I'm a visual person. Okay? I've been learning as a trainer that many people have a hard time retaining information if there's so much narrative and there's so much text. So I usually have updates, checklists, and bullet points to help the retention of that information. You'll also see similar graphics. I also want the attendees to be aware of the regulatory agencies that may come knocking on your door or sending you letters for mandated audits. I always have compliance alerts. I add tips, and these tips have been researched and proven to be really successful in creating a risk management strategy. I love adding best practices, not only mine, but all of you. And I've received so many feedback and on information, and I've been able to learn as well. Okay. I also, since I deal with fines and penalties, okay, I do deal with penalties and the cost of non-compliance. I do that to make sure that everyone who attends is aware on the impact of violations. Now, I do have to let you know that as a compliance officer, there has been many companies that are not as embracing about me reminding them on how they can be a risk or how they can have violations. And in fact, there are some employers that wait until they're in litigation to take these things seriously. But we cannot. We are obligated, no matter in which role that you play. It is important for you to be able to share this information for all of your employers. I usually add a legal update. Now, that's a short slide on some of the upcoming regulations that might be trending and information that is important for all of you to be aware of. I usually add other special bonuses. I want to make sure that all the attendees get as much information as they need. Now, this is after the presentation, not before. Okay, and we may never get to them. That's just more information and more bonus for all of you. We will, depending on the topic, have some resources and links, free links that you can access to be able to get more information on your topic. All of these components are here to enhance your training experience. I'm so excited. We're going to have for 2020 SHRM recertification credits. I'm thrilled. I would also like to offer the HRCI, but that may be coming down the road. I'm still, thrilled about this. I am glad this is also another reason why these trainings are going to enhance your training experience. And also, if you need recertification credits, you've come to the right place. Now, what's new? Most of you by now know that the I-9 form had expired effective August 31st, 2019. We need to prepare for changes that are coming. However, the new I-9 form has not been launched yet. I check every day. Okay? And the Department of Homeland Security mandates that you use the expired I-9 form listed here. Now, this is a compliance best practice. Okay, whenever a regulatory agency asks you to do something that is not consistent with the regulation, jot it down somewhere. Put it as an email to yourself. Have it as an administrative memo, because many auditors don't know all the idiosyncrasy of the dates in that. And you could be asked, why did you have an expired document? So you need to make sure that you indicate that somewhere. Okay. Now, the Department of Labor is also scheduled to update their FMLA forms. Now, most regulatory agencies offer a public, comments. It's information whenever they think of changing a regulation or a form to ask the public for feedback. This is usually in a time frame of 30 days or 60 days. Now, that deadline has passed. So we should be looking out to see the new FMLA forms coming very soon. And if not before the end of the year, certainly in the beginning of the year. Now, the EEO-1 pay data reporting deadline had been extended from September 30th, 2019 to January 31st, 2020. So those of you who are required to submit those surveys on the 2017 and 2018 payroll data, you still have the opportunity to do so. Now, the EEOC also requested some public comments and feedback on the future of the EEO-1 pay data reporting requirements. Now, that deadline had passed. So in the next couple of weeks, and certainly in the beginning of 2020, we are going to see certain decisions about the future of the EEO-1 pay data reporting. Until I see that, I'm always going to prepare, and so should you. And lastly, the Department of Labor overtime regulations have passed, setting the minimum salary threshold for overtime eligibility at $684 per week and $35,568 annually. Now, for those of you who wanted to drill down even further, it comes to about $17.01 on an hourly basis. And this will make an estimated 1.3 million additional U.S. workers eligible for overtime. And it's going to start January 1st, in just a couple of weeks. Don't wait until then to plan. Do it now. And I will help you with the tools that I have here listed. Now, I wanted to mention, because the I-9 changes were requested and there were certain updates and that, I just wanted to let you know, since I do I-9 compliance in a really, really valuable training that I'm offering here to all of you, where you will also receive a compliance and internal I-9 form correction process and storage program. It's a value of $150, but we'll get to that towards the end of the presentation. Okay? Now, most of the changes that are proposed are changes in administrative explanations. It's really just to clarify certain confusion. Now, I am sometimes a compliance cynic, but anytime the regulatory agencies want to make things simple, they don't always hit the mark. Okay, so be on the lookout for more compliance solutions training on how to be able to review and complete the new I-9 form. So most of the changes are really clarification and administrative. They're going to mention something about remote I-9 processing, which is great since a lot of my clients really are asking on, how can we handle remote I-9 processing? The use of NA, is it an obligation or is it optional? Now, Section 1, which is the employee section, can only be completed and corrected by the employee. So they're going to have some information clarifying that. They want to also refine the list of acceptable documents. So that's going to be a change. And overall, they really want to simplify the process. I hope they really do that. They also want to integrate the I-9 and E-Verify rules, which is absolutely awesome. And I hope they can do that. Now, here is my promise to you, okay? We're going to learn who are the regulatory agencies and what their authority is. We're going to learn what is compliance and how it's defined. We're going to also learn what regulations are trending, not only now, but in 2020 and even beyond. We're going to see what the cost of non-compliance is. We need to really take a really good look at that. Now, we're going to also see what state-specific regulations are a challenge and how multi-state regulations are an employer's big headache. We're going to see how HR compliance training increases the ROI more effectively than other competitors. We have a special offer for the attendees. We have open Q&A, and because this is an automated webinar, submit your questions anyway, and I will be able to respond within 2 to 24 hours. A little about me if you are not familiar with me, but I see that some of the attendees are familiar and they're part of my HR life. And so thank you so much for joining me and helping me make this a great presentation. Okay, so I am Margie Falk. I have a PHR and also a SHRM CP. I'm an HR compliance officer for HR Compliance Solutions. I am a compliance geek with over 14 years of HR compliance experience. I am a workaholic in recovery, although my Mr. Wonderful begs to differ. I offer customized compliance tools proven to reduce risk. I live in sunny Florida, formerly from New York. I'm a Latina HR compliance professional who loves to assist in providing an effective risk management strategy for employers, HR managers, and other professionals. Now, why should you listen to me? Okay, as part of my commitment to the HR and compliance industry, I'm offering high-value, low-cost webinars, and I offer free customized tools for all the attendees. I've conducted compliance webinars since 2016 for over 21 compliance institutes, where they charge you from $250 or more for the same presentation and training I'm going to provide for you for less money. I'm offering the same webinar. I offer free customized tools for all registrants, and all the tools are customized. Now, I wanted to share with you that these are only some of the compliance institutes that I work with. I love working with them. If you check onto any of their websites, you'll see that I'm one of their panel speakers. I provide training at least once or 3 times out of the month for each of them, which keeps me very busy and keeps me updated on laws and regulations. And I love working with them, but I want to sponsor my own webinars for my friends, colleagues, and clients of HR Compliance Solutions. And you can make that happen. And so Go onto the website, you will see me, and you will see the amount of money that's being charged for those webinars. Now, what is compliance and why should you care? Well, compliance is the act of complying with a command, desire, or a rule. Now, compliance is also defined as adhering to requirements, standards, or regulations. You also must ensure that your company as a whole is in compliance with any federal, state, and local external laws, regulations, or standards relating to your state and industry. Increase in audits and regulatory agency is on the rise. Okay, they are now spiking. Many regulatory entities are holding employers accountable for violations. The cost of non-compliance can reach into thousands of dollars if employers don't take the compliance action now. Now, what regulatory agencies have the authority to investigate, audit, levy fines, penalties, and criminal sanctions? Well, we know of some of them, and we know that there is the Department of Labor, the Equal Employment Opportunity Commission, the EEOC, the Department of Homeland Security, DHS, OSHA, American with Disabilities Act, ADA, in addition to state and local jurisdictions, which also must be followed. And for those of you in multi-states, wow, there's a lot of regulations that you have to mitigate. Now, what regulations are trending now? You may be able to share one or two. I have many of them to share. Overtime, salary history bans when hiring, ban the box, okay, which is criminal background screening regulations, pay equity, the new tsunami for employers in 2020, retaliation, paid leave, off the clock work, Fair Labor Standards Act, FLSA, immigration violations, I-9 form correction, compliance and visa violations, Family Medical Leave Act violations, reasonable accommodation, sexual harassment and sexual harassment mandated training, all federal, state, and local and multi-state jurisdictions. Now, the cost of non-compliance should be very clear for us. Okay, the cost of fines and penalties also start by disgruntled employees, audits, targeted industries. For example, the Department of Labor, as an example, have audits that they have targeted certain industries. For example, if they're talking about overtime, they may target industries where it has been historic violations. For example, construction, landscaping, retail, farming, okay, which usually they don't really follow a lot of the regulations. Okay, I want you to learn how to be an employer risk or ambassador as a manager, and the goal is for you to be an ambassador. Now, we are going to mention vicarious liability, which is really defined as managers and HR professionals liable based on their actions or inactions, and we need to take that seriously. Many times, employers who provide training and their managers are still based on their actions or inactions, making problems for employees, then it's possible, okay, that managers and HR professionals could be charged civilly in addition or in lieu of the employer. So we need to make sure we get started on this right away. We're going to learn how training is the most cost-effective option to reduce fines, penalties, and criminal sanctions. Now, how can we create a risk management strategy that works? Attend compliance trainings like this. You're already in the ballpark of making sure that you understand the regulations and that you accept what your role is in the company. Okay, update, enroll your managers in these trainings. I have a manager and HR boot camp that's coming up in February. It is a 3-hour training only on compliance. Make sure you enroll your managers, and there could be a group rate for you. Enhance your employee handbook. policies, procedures, and practices. Register for future compliance webinar series from HR Compliance Solutions. Add your name to the webinar subscription for HR Compliance Solutions to get more updated information on future compliance training, but also updates on what's trending. Update your employee handbook for 2020. Very key. Now, changes in regulations always, in my mind, go hand in hand with changes in your employee handbook. So if you have questions about your handbook, if you want to revise your handbook, if you want to be able, to make sure and ensure that you have everything that you need, reach out to me. I always answer questions. And if you want the service, we will be able to work hand in hand with you. Now, how do you think employers and managers are feeling right now with all the violation updates, compliance, and changes in regulation? Well, the goal I have is to have you create a risk management strategy to avoid violations. There's no need to give regulatory agencies free money. Let's start with some federal regulations. We're not taking a deep dive. Okay, we're just going to look at how the regulatory agencies and the enforcement arm follow up and are able to regulate their laws. So here we have the seal of the U.S. Equal Employment Opportunity Commission. Some of you very familiar with this. And right next to it is the Civil Rights Act of 1964. Now, many of you see it as, Title VII. So depending on how you identify. And then on the bottom, we see the Department of Labor. Okay, and right next to it, we see the enforcement arm of the Department of Labor, which is the Wage and Hour Division. Now, the Civil Rights Act of 1964, Title VII, is the law protecting employees and candidates from discrimination. Many employers forget that. It's for candidates as well. You may never even see some of those candidates who may be alleging discrimination until the charge is actually official. Okay, so the EEOC is the enforcement arm of discrimination. Now, what does the EEOC do? The U.S. EEOC is responsible for enforcing federal laws that make it illegal to discriminate against a job applicant, again, the job applicant, or an employee because of the person's race, color, religion, sex, including pregnancy, gender identity, and sexual orientation, national origin, age, disability, or genetic information. But the EEOC also enforces those actions or inactions by employers called retaliation. Okay, and at times, I call this the second level penalty. If there are any allegations of retaliation, the cost in fines and penalties usually supersedes the original complaint. That's why I call it the second level penalty. Okay, so they have the authority to be able to investigate, okay, to also audit, to continue with an audit, even if the employee changes their mind. And why should we care? Okay, so the EEOC is the enforcement arm, the authority to investigate, make charges, conduct workplace audits, and levy penalties. Okay, now the EEOC also provides guidance. Now I put that in red, okay, because the guidance coming from the EEOC, which has its own page on the website, are guidance tools that help employers on decisions that have really limited involvement with the EEOC. An example of that is criminal background check. Now, while the Civil Rights Act does not have any regulation against criminal background checks, the EEOC has guidance, and they use that guidance when there is an impact of violation of discrimination. For example, for the ban the box, okay, and criminal background checks, it impacts more African American and Latino males. Okay, so you're going to see many, many guidance, okay, which in my mind assumes that the EEOC wants us to follow it. Here's the Department of Labor. The DOL is the umbrella organization for employee protections in the form of wages, and the Wage and Hour Division is the enforcement arm of the DOL. Now, what does the DOL do? Well, the purpose of the Department of Labor is to foster, promote, and develop the well-being of wage earners, job seekers. We're back again with the job seekers, not only employees. And they focus on compensation of those employees and candidates. Okay, and they are able to audit. They are able also to investigate. Now, because the Wage and Hour Division is the enforcement arm of the Department of Labor, I really wanted to make sure that you were aware that they are charged with ensuring that the regulations are followed. And as you can see here, it's what is called the FLSA officer. And if you see, he, in this particular case, is in full uniform, in full weapon regalia. As you can see, there's a weapon there. And he or she will have the authority to come onto your property, check your documents, check your payroll, check information and timesheets, based on the subpoenas that they have or the warrants. Okay, they do exist. Okay, so don't think that they don't. Now, here's an example of federal and state regulations clashing. Now, we did find out that the Department of Labor has overtime regulations that have passed and are set to start in January 1st of 2020. And this will make an estimated 1.3 million additional US workers eligible for overtime. So we know this. But now we have some state overtime regulations. Okay, we have California, New York, Washington that have competing overtime regulations. What are employers to do? And we'll answer that question. Okay, so the impact for the employers is changing their workforce to conform with the federal or state regulations. Now, it's important for us to really focus on the federal versus state overtime exemption rules. And that's because it's state regulated, okay, and it's very different than the federal, okay, and you'll be able to see that in some of the examples that I have here. Okay? And so not all of those overtime exemption regulations are going to be similar. One of the other challenges of having, different state and different federal regulations. But let's get into that. How do states differ with overtime regulations more than the federal regulations? So the state regulations, if your state does not have a standard overtime law for non-exempt employees, then the FLSA's standard overtime requirement applies. Okay, all right, and it's typical that it will be 1.5 times their salary after 40 hours. And many states follow the FLSA overtime exemption. But if your small business is located in one of those states that have an extra or a different overtime rule, you need to make sure you comply. Okay? If your state has its own overtime exemption law, the first order of business is to examine your state's requirements. I have a few examples here. Now, I always like to use California. Now, why? Well, because California happens to be the most employee-centric, which is employee-friendly, regulations. And what that really means is they have the most protections for employees, while Florida, which I'm in, happens to be employer-centric with more protections on their employers. And so it's important for you to know what states that your employer works in, if not now, for your future. Okay, and so California has an overtime regulation that is much higher than the federal guidelines. Okay, and it's supposed to take effect in 2020. And as you can see here, they have, for 25 or fewer employees, $49,920 a year, okay, is what their regulations for non-exempt employees are. And then there's 54,080 if you have more than 26 employees. So you have to make sure, okay? And the way to handle that is to make sure you get onto those state regulation websites. Here's New York, another favorite of mine because I'm formerly from there, but it's also employee centric, which is employee friendly. And so many times you'll have California make changes and New York make the similar changes. Okay, and so New York has taken another approach. Instead of the $684 per week that is the federal regulations, New York has a weekly amount of $1,125 per week, obviously higher than the federal. Okay, so we need to make sure. Okay, we need to make sure that not only is it for 11 employees or more, but effective this month, employers with 10 or fewer employees need to be able to comply with this. Now, when federal and state rules collide, what should you do if your employees are subject to both FLSA, which is federal, and state overtime exemption rules? Now, here, the standard most favorable to the employee prevails. And we have another slide that explains it a little better. Let's talk about multi-state regulations. Employers in different states, okay, where they have employees, this is a landmine for them. Now, the challenges for multi-state organizations are pretty typical. The violations of regulations are hard to keep up with in multi-state organizations. And I'm here to attest that many regulations change, sometimes on a monthly basis. It is hard to keep up. Pay regulations may differ significantly from state to state, so it's not a one size fits all. The laws on criminal background checks and other regulations can impact even within states and their local jurisdictions. And what am I meaning about that? We do have California, which has Ban the Box. But if you look in San Francisco, okay, which is a county in California, you'll have even stricter regulations. So it's not only the state, it's not only the federal, it's local as well. Now, organizations with multi-state locations have to ensure that the regulations in the most employee-centric, employee-friendly state supersedes all other states. Now, paid leave in different states can impact financially if organizations offer all paid leaves across all the states. Now, so what that really means is if you have employees in 10 states and 3 of those states have mandatory paid leave, it is prudent for the employer to only offer the paid leave in those specific states because they're mandated. If you offer it across all states, as some employers try to do, you're going to find that your budget is going to be impacted. Now, here are some of the workplace regulations impacting multi-state organizations. And what you're going to see when we make the comparison of what is employee handbook or standalone must-haves, you're going to see some correlation here. And here are just some of the ones that we mentioned, okay? And depending if that employer has employees in different states, they need to comply, not only in the headquarters. When there are federal, state, and local regulations, the regulations with the most benefit to the employee supersede. Said a lot better. Now, the employee handbook is one of the 4 documents reviewed by lawyers in employer litigation. And changes in regulations go hand in hand with changes in handbooks and in standalone policies. Now, what are employee handbook must-haves? Here's a nice list, and you can see it correlates a little bit with the multi-state. So it's important for you to make sure that you understand what regulations are a must-have for employee handbooks. In addition to that, you need to also be aware of what regulations are in the state specific. Okay, again, if you have questions about your employee handbook, reach out to me. I'll answer some of those questions. But as you can see, there are many regulations that are mandated. Now, of course, as I said, I'm a visual person, so I like the option of also looking at graphics of all the changes that are happening. Okay, some of these changes have happened already and some are scheduled to happen. So if you have not updated your employee handbook since 2018, you may right now be at risk of violations that should have been in place. We need to be careful with zero tolerance policies. I mean, those policies that are in your handbook, but also those that are in standalone. And the fact here is the problem is in being consistent. Now, the challenges with zero tolerance policies, it's that most of the zero tolerance policies were really established to demonstrate a strict policy for those policies like sexual harassment, violence in the workplace, domestic violence. Okay. And while that's important and you don't want to have a low tolerance for that, but you need to make sure if you have zero tolerance policies that you're really consistent with how you manage those. Now, zero tolerance policies really eliminates at times second chances for violations of policies by tenured employees. So you need to make sure that you have an option of what type of policies that you have in different aspects. And zero tolerance policies don't allow the employee to have any discretion with discipline against violations of policies. An example of this is you have a zero tolerance policies on drinking and substance abuse in the workplace. I'm not talking about events or parties or holiday events. I'm talking about having a zero tolerance policy that says anyone who's caught drinking will be terminated because you could be in violation of American with Disabilities Act because in certain cases, alcohol and substance abuse may be indicated of being a disability. So you need to make sure that you are careful with that. And it loses its impact if it's not consistent. Training of managers on compliance in the workplace is a good legal defense for employers. Okay, and this is true many times that if your company has had training like this one that you're attending, and hopefully, the future trainings that they pay for, it makes your company look really good. In fact, there have been some times where if you're audited, but you've provided compliance training, your risk could be decreased. And in fact, some of your fines and penalties could be waived or lowered. Okay, so make sure that you make a copy of any of these trainings that you attend to make sure that your employer knows that you're already being proactive. The best practice is train your managers. I've been saying this, I say it often, okay? Make sure this is a low cost strategy. And many times training is the first thing that creates a budget cut, but it is so valuable, okay? And you see the value right away. Now, many managers are hired and promoted because they may be good as an employee, but many do not have the benefit of getting training. Okay, how many managers have you had that you thought could use some training? I know I have. Okay, now my philosophy about managers who are not willing to be managers, and I take a really strong stand on this, is give back your money, give back your title. Okay, if you can't be a manager, okay, then you don't have any right to be a manager. But if you want to be a manager, get training. If they don't offer it, ask for it. It's your right. And I'm going to say that you'll be helping your company and yourself. Now, managers with good training can be the ambassadors of a company and reduce risk. Isn't it worth giving them the tools that they need to be good partners with your HR professional or your leadership? have managers and supervisors and your HR team attend compliance bootcamp training as your New Year's resolution for your risk management strategy for 2020. Now, here's the special offer. I have an immigration compliance training for 2020. We're going to learn how to manage the strict regulations. This is scheduled for January 14th, 2020 for the low price of $49. And if you compare for the other webinar compliance institutes, you're going to see the value. Not only that, if you register by January the 10th, you will be paying $49. Anything after that could be higher. Now, this includes, okay, a new I-9 document auditing and visa changes workbook. It's a guide, it's a toolkit, it's a program, and it's a value of $150 for all who register. Take advantage of this. You're going to learn because there's many I-9 audits that are happening and also many visa changes that are happening. Let's recap and see what we've learned today. Regulatory audits are on the rise. The cost of non-compliance impacts employers' budget via fines, penalties, and criminal sanctions. Compliance training is an effective low-cost risk management strategy. Attending compliance training by HR Compliance Solution provides a high-value, low-cost option to reduce fines and have an effective ROI. Now, the cost of non-compliance, okay, for employers, okay, obviously, reduce your risk by 80%. Join us. Have your managers attend some of these trainings, okay? Order for groups, which are going to be less money. Take advantage of this for 2020. Now, one of the easiest and cost-effective arsenal in your risk management strategy is training. I'm not talking about staff development. I think those are great as well. But before you develop yourself, learn what the compliance topics are. For the cost of a 3-hour manager boot camp of $199 or less, okay, you can train 20 managers and you already have a risk management strategy that reduces your risk. Take advantage of that, okay? Make sure you train, all right? And the boot camp includes from 9 to 11 compliance topics, FMLA, document, volatile terminations, paid leave, ADA, reasonable accommodation, all the information that you as an HR professional or a manager, office manager, or leadership is going to find valuable. Here's a free employee tip, okay? Include a mediation clause in your employee handbook. It won't preclude employees from litigation, but they must go through your mediation process first, okay? And this shows good faith in trying to resolve your issues if there is litigation. Again, SHRM recertification for trainings coming up in 2020. And I just wanted to go back on the mediation process. Having that mediation clause in your handbook, okay, is critical. Put it in where the employees can see what the prohibited employee conduct is. Make sure you have a multi-level complaint procedure, which also helps. Okay, it doesn't preclude them from suing, but it has them offer you the opportunity to try to resolve the issue first. Here's your free Department of Labor article on off-the-clock audits and how to mitigate compliance. It could be downloaded here at the end of this training. I want to thank you all for attending this short compliance training and overview of services that are available to you. If you have questions, make sure you send those questions in the chat box. I will respond to those questions promptly. Okay, if you have questions about services or anything else, reach out to me at mfalk@hrcompliance.net or give me a call at 407-914-7336. This is the end of the training. I'm so glad you're sticking with me. I know that there's a lot of information here. Use your replay, okay, as an information tool for you. Sign up for the website for you to get the monthly newsletter. I'm not going to stalk you. I'm not going to send you 100 emails. Just information on updates that are happening and updates on training on a monthly basis. Don't forget to send questions to mfalk@hrcompliance.net. I will respond and answer all questions. Stay connected to HR Compliance Solutions, which is going to be your compliance best friend. Make sure you sign up on the website. Make sure you send me questions and information. And also, if there's a topic that you think is of value, make sure you send it. Most of the people who send topics that are selected are going to be featured in the newsletter. Okay, so have you and your company part of the spotlight. Yeah, I want to wish everyone happy holidays, happy new year, have a safe holiday, and make sure it's a prosperous new year. Thank you. Goodbye. Be safe. And I look forward to seeing you virtually in the future. Thank you so much. And I appreciate you attending this. So thank you very, very much.